Namaskar. So I am Mr. Gururaj N. Joshi, once again back with you with the Preamble of Indian Constitution. I was talking to you about the Preamble. In addition to that, we are having some fresh information. So today's lecture is meant for that. While talking to you on that day, 2 days ago, I told you that the President of India, that is the head of the state, who is the head of the state, is elected indirectly. I mean, by the members of parliament of both houses and MLAs of all the legislative assemblies of all the states, and according to 54th Amendment, the members of the Union Territories of Delhi and Pondicherry are also allowed, are also made as the part and parcel of the Electoral College, and which Electoral College elects the President of India. So I was talking to you throughout the preamble. The makers of the Constitution have made it very clear that the people of India are supreme. So you can take this republic also, wherein that is the people of India, after every 5 years, elects the government. So first the people elects the legislature. For example, parliament, that is House of Lok Sabha or lower house of the parliament. And the person who commands the majority, he approaches or he will go to the president and asks or stakes the claim of formation of the government. And then the President of India gives him, permits him to form his own government. So first the people used to elect the legislature or Lok Sabha. So in parliamentary democracy, after the people electing the legislature elects or forms the executive. As you know, Prime Minister is also one among the members of the House of People or lower house of the Parliament. So generally, after the election, the party in power, I mean the political party which commands the majority in the lower house, used to elect its leader. He will become the Prime Minister, and then he forms among the members of the legislature his team, that is called executive. The appointment of judges comes. There is the executive of the Union of India, which prepares the list, and with the consultation of the Chief Justice and the Chief Justice of the states, as the case may be, the judges have been appointed. So everywhere, that is the people who, and even that is the legislature or the Lok Sabha is accountable, and it is the executive is accountable to the legislature, that is to the parliament, that is to the lower house or Lok Sabha. So also, this is the checks and balance system in the Indian Constitution. So three things Even in Gopalan versus State of Madras, Justice Patanjali, the then Chief Justice of India, has made it very clear that in India, according to the preamble and according to the Indian Constitution, that is, the people are very supreme. So I was talking to you, and in this connection, I would like to, for the students of law and even for the UPSC students, 3 dates are to be very important. As we know, Independence Day, that is 1947, August 15, is the day of independence. Then comes November 26, 1949. On this day, we adopted the Constitution of India, enacted the Constitution of India, and give to ourselves. So, on 9th December 1946, the Constituent Assembly first started its session, and as we know, on 26th November 1949, we set our Constitution in motion with some of the provisions. Some of the sections were with immediate effect, they came into force, and January 26, 1950 is third date, which on that day that is the Constitution, the entire Constitution with all its provisions came into force. So, there is another doubt for the students, why not on 26th of November 1949, instead of that, why we enforce the Constitution on 26th January 1950? So, it was in the year 1929, December 31st, on this day, on the banks of river Indus River or Sindhu River, at Lahore, which is the capital city of Punjab province of Pakistan today. At Lahore, Jawaharlal Nehru, on that day, that is, I repeat, on 31st December 1929, in the midnight, for the first time, hosted the Indian tricolor or unfurled the Indian tricolor amidst of chanting of Vande Mataram, etc. And then he called in this historical session of Lahore, even Subhash Chandra Bose and almost all prominent leaders, including Mahatma Gandhi ji, were attended. And Nehru ji was president. Being president, he called the Indians to celebrate 26th of January 1930 as Independence Day, because he promised the people that the Congress will start. For the first time in this session, Congress demanded Purna Swaraj or complete independence. That is why he called the entire nation to observe 26th of January 1930 as Independence Day because the Lahore Convention of Congress meet on the river bank of Sindhu tributary Ravi or so, the Congress under the lead for the first time full Swaraj was demanded, and in memory of that day, that was 26th January 1930, in memory of that day, January 26, 1950 was selected as the day on which we started, our constitution came into force. So also, I was talking to you on the case laws. It was in the year 1960, for the first time, that is in Berubari case, the Honorable Supreme Court of India held that the preamble itself is not the part of the Constitution. When preamble is not part of the Constitution, amendment of the preamble under Article 368 doesn't arise. So, this principle of the Supreme Court is based on Pacet Caesar Tacitum, which means if there is express mention of certain things, then anything not mentioned is certainly excluded. On the principle of this, which means when there are provisions which are expressing certain things, then going to preamble and interpreting the Constitution is not that necessary, was the view of the Honorable Supreme Court in Berubari case of 1960. Whereas after 13 years, that is, it was in the year 1973, as I have already told you about the Keshavananda Bharati case versus State of Kerala, 1973, Supreme Court, 1461 AIR. For the first time, the 13 members bench of Supreme Court judges, the bench was of 13 judges, comprising of 13 honorable judges of the Supreme Court, sat, and the Keshavananda Bharati versus State of Kerala was not only milestone in the history of, in the constitutional law history of India, but it is also a very important and crucial point. In this case itself, the basic structure of Indian Constitution, the basic principles of the Indian Constitution is given final say. And in this case, it is held that preamble is part and parcel of the Constitution, and also held under the principle of basic principles formula. The Parliament under Article 368 cannot pass such legislation, such law, such act, which is against the basic principles of the Constitution. This was a very, as I have told you, a very important judgment. So almost all students must read once or twice this judgment. So you may ask me, what are all those points? What are all those things which have been held as the basic structure of Indian Constitution according to Keshavananda Bharati versus State of Kerala of 1973? Yes. First of all, what the court held is supremacy of the Constitution is the basic structure. Republican nature of Indian Constitution, democratic nature of Indian Constitution, secularism, socialism, separation of powers between the center and the state, clear-cut separation of the power between executive and legislature, so also clear-cut separation of power of legislature, executive and judiciary, independent and efficient judiciary, fundamental rights, directive principles of state policy, unity and integrity of the nation are some of the main points as per this judgment. Same is upheld in All India Judges Association versus Union of India 2002 Part 4 247 Supreme Court. So also State of Bihar versus B.M. Shah AIR 2000 Supreme Court 1296. And same is reiterated by 5 judges of the Honorable Supreme Court of India in Indira Nehru Gandhi versus Raj Narayan AIR 1975 Supreme Court 2299 Supplementary SCC page number 1. So with this, judicial review is also the basic structure of the Indian Constitution. This has been held by the Supreme Court of India in Additional Secretary versus Alka Subhash Gadia 1992 Supplementary page 1 SCC 496. Rule of law. Article 124 subclause 2 and Article 217 subclause 1. Consultation with Chief Justice is a must. So far as the salary of the judges is concerned and the secular character of the Constitution, non-discrimination of people by the state on the basis of religion. This has been held in Aruna Rai versus Union of India 2002 Part 7 SCC 368. So on all these have been held as the basic structure or have been covered under the basic structural formula of Indian Constitution. And the power of judicial review is also held as the basic structure. Unless the power of judicial review to judiciary, how can the judiciary consider the legality of the amendments is the big question. That's why the court held that judicial review is also a basic structure of the Constitution. A catena of decisions, that is Minerva Mills case, Fertilizer Corporation's case, SP Sandeep Kumar's case, special reference to the President of India, number 1 of 1964, that is Keshava Singh case. All the students are also, or the general readers must read this Keshava Singh. At the time of discussing the powers of the legislature, definitely I would like to go in detail with this Keshav Singh case. So also Indira Gandhi versus Raj Narayan case, very recent judgment, Kivoto Holland versus Jichilu, and then Delhi Judicial Services Association versus State of Gujarat, 1991, Part 4 SCC 406. This is also very important case. That is Delhi Judicial Service Association versus State of Gujarat. At the time of discussing the judges, the judiciary, I will definitely take you in detail on this judgment, how the state, the police force acted against a judge who was a very sober judge. So all these case laws are very important. Judicial activism. In judicial activism, that too, in the year 1950, in A.K. Gopalan versus State of Madras, AIR 1950, Supreme Court, page 27, the Honorable Supreme Court compared the power of judicial review of the Supreme Court with apex courts of England and America. So, comparison of the other constitutions with the Constitution of India and finding some solutions within the framework of Indian Constitution is the important work for courts which is held in this A.K. Gopalan versus State of Madras. The same is held in M. Nagaraj versus Union of India, 2006. Here also, liberal interpretation of the Constitution is held. Then, so far as the equality, liberty, and fraternity are concerned, we can't have liberty without fraternity and without equality. And we can't have equality without fraternity and liberty. So, these are the three things which are the important points or important salient features or characteristic features of democracy. So, we are having many judgments, that is S.S. Bala versus Sadhana 1997, Part 8, SCC 522. So also, most of the judgments, that is Judicial Accountability or Subcommittee on Judicial Accountability versus Union of India, 1991, Part 4, SCC 699. But we must found, as I have told you, solutions under our Constitution. Friends, hit the bell icon, subscribe, share, and comment in the comment box. I will see you in the comment box. Till then, goodbye, bye bye for now, namaskar.